Good afternoon. Welcome, everybody. We're all very excited to listen to Peter and let us know what's going on with recent business cases that could impact your technology practice. Very happy to have this sponsored by Goodmans, iTech Law, Silicon Valley Arbitration Mediation Center, Toronto Lawyers Group, and Cantech Law, of which I'm the president. This is an annual talk that we all very much look forward to. And I think that we're always interested. In fact, Peter said it's been going on so long that now cases have gone into appeal. So we're going to have updates of former cases. And I want to welcome for the first time the Silicon Valley Arbitration and Mediation Center who have joined us. As we all know, Peter is a leading technology lawyer. He's a partner at Goodmans and in the dispute resolution group and co-heads the technology law group. Has experience in national and international matters as an arbitrator and mediator. He's very active and devotes a lot of his time to Technology Law Association and currently is very involved with iTech Law as on the board and on the executive. He's been counsel in key software and internet cases, a former Montrealer who's now joined the group in Toronto. I want to not take much more time, let Peter get started. Just a few housekeeping matters. Peter will take questions during the talk. At the bottom or top of your screen, there's a Q&A feature, and we hope you use it. He will answer the questions as you go. And if you have any questions, I think you'll see it as part of his slides. So my part has now ended. Congratulations, Peter. I look forward to learning a lot of cool things.
Thanks very much, Nancy. That's very kind of you. And thank you also to all the organizations that are co-sponsoring today, including the local associations, Cantech and TCLG. I personally attend events run by each of the four sponsors, and they really put on great educational and network sessions. And I do encourage everyone to check out their offerings and consider joining all four organizations. As Nancy said, I'm delighted to take questions as we go. If you click on the Q&A button, eventually they'll be fed to me and I'll try and fit them in and answer them as we go along. So there's no need to wait for the end. So there are 7 topics that we're going to cover today. You see them on the screen. 2 or 3 of them we're going to deal with very quickly, the rest in a little bit more depth. But up front, I want to offer all of our appreciation to my colleagues, Jesse Cohen and Samantha Galway. They sifted through an awful lot of cases to find some of the gold nuggets that we're going to be using today. And as usual, we're just dealing with bread and butter technology contract issues, except maybe the innocent misrepresentation issue we're going to cover. That one's a little bit more out there. As usual, many of these topics arise from emails that people have provided to me over the last little while of topics they've proposed to discuss. And what we're going to do is ask you to keep the suggestions coming so that we have the benefit of everybody's topics and things they want to talk about year after year. Is everybody here, I think at this point knows, because we've been doing this for many years now, what we do with this session is look at individual cases to try and illustrate how the courts deal with real life business problems. And when we're done with today's session, we will email everybody a copy of the slides, which will include the names of all the cases, citations and hyperlinks to all the cases, so you don't have to jot any of that stuff down. It'll be sent to you later. One last introductory word. People who've done this with us before will remember that we usually cover not just Canadian cases, but some international cases. This year, sticking with the COVID no travel theme, we're going to stick to just Canadian cases. For international content this year, I encourage you to check out and join iTech Law. Its next North American conference is going to be in San Francisco in the spring, COVID permitting. If not, there'll be an online event that I'm sure will be terrific. So let's go on and talk about the first topic. Most agreements that I see include a sentence that says something like, time is of the essence. Some also include extensive timetables where each obligation that has to be performed is listed with a date when it has to be performed. Some contracts have some obligations, some dates, but many obligations don't carry a timeline. And of course, there's some agreements that carry no dates for performance at all, just a time is of the essence clause. Before we get going with our first case, if we can put up the first poll, and let me ask you, do you include in your contracts a time is of the essence clause? Just so you know, just short, over 490 actually people have registered for this event, which is both intimidating and I'm quite honored by it. But obviously there are a huge number of experts in this field. And so I'm very interested with a few of the polls that we're going to do to get your views about these things. So why don't we bring up the results now? They're still going up, but I don't want to keep people too long. So let's take a look. So here are the poll results. Interestingly enough, almost always and occasionally seem to be carrying the day, which is an interesting split. It's almost like it's not quite a bell curve because about half the time doesn't get a lot of people. But that's a very interesting result if we want to take that down. So let's take a look at a case that considered a time is of the essence clause. So, and this case, the DeMillo case, is a decision of the Court of Appeal for Ontario, and it's about a purchase. Now, this particular case is about a purchase of land instead of a purchase of technology, goods, or services, but the same law applies. So we'll try and illustrate the point. And here, Mr. DeMillo sold some land, and the deal was that the purchaser would construct an industrial building on the land. And if the building was not completed within 30 months, Mr. DeMillo, under the contract, had the option to repurchase the land at essentially the same price as the original sale price. But the agreement was silent about when that option of Mr. DeMillo to repurchase, when that option had to be triggered, what the deadline was for triggering it. So won't surprise you to hear, since it ended up in court, that the building was not built within the 30 months specified in the contract. And Mr. DeMillo agreed to extend that 30 months for an extra 12 months. And that total of 42 months expired in March. Doesn't matter what year. In August, so then moving from March to August, the purchaser entered into an agreement of purchase and sale to sell the property to a third party, which he wasn't supposed to do under the contract. But in the end of the day, that contract did not close. Now, sticking in the same year, in September, Mr. DeMillo exercised the option to purchase. And at the same time, roughly, the purchaser asked for an extra 12-month extension on the 30 plus 12 months, and Mr. DeMillo refused this time. And then a further 7 months later, Mr. DeMillo sued. Now, there was a time is of the essence clause in the agreement, so the question became, did that mean that Mr. DeMillo had to act quickly or had his option expire? Because you'll remember there was no specific timeline written into the agreement about when he had to exercise his option. And here the Court of Appeal said that no, the option did not expire. And this is important. The phrase time is of the essence, the court said, means that a breach of the time limit written into the contract permits the innocent party to terminate the contract. In other words, the time is of the essence clause does not create a time limit. Instead, it dictates the consequence that flows from failing to comply with the time limit that is otherwise written into the agreement. So consequences, not setting a time limit itself. And because there was no time limit in the DeMillo case written into the agreement, the time of the essence clause did not have any effect. But the story did not end there. The law is that where no time limit is specified for the exercise of an option, a reasonable time limit is implied into the contract. Now, since Mr. DeMillo didn't have a time limit for his option, the court had to say whether the time he took, you can look at the slide and see sort of how that played out in time. The court had to say if the time he took was reasonable, and in all the circumstances here, the court said yes. So what's the lesson here? And the people who are participating, obviously, a lot of you have tremendous experience with dealing with these kinds of situations when you're drafting agreements. Well, maybe the lesson is that it's very helpful to have deadlines specified in the contract for each important operative step. Obviously, there are steps where people don't specify everything and there's no need. But the time is of the essence clause is not of any help to create a specific deadline. And without a specific deadline, you would be, or your client would be, at the mercy of what the court thinks is a reasonable time to exercise a discretion. And that might not accord with what your client's commercial need happens to be. Of course, if you're on the other side, if you have a deadline in the contract and there is a time is of the essence clause, then perhaps it's a good idea to warn the client when the situation arises that if a timeline is missed, what could happen is that the contract could be terminated by the other side. So it can be major consequences from missing a deadline when there is a time is of the essence clause. Let's move on to the next case. This is the Dow Chemical and Nova Chemicals case. It's a case from the Alberta Court of Appeal that came out 2 months ago, so quite new. It's a supply chain case about chemicals, but just as easily it could have been about something in the technology sector. So here, Nova Chemicals was building a plant, or built a plant that was to make ethylene. That was the chemical at issue for a company called Dow Chemical. But what's important here is that ethylene was always meant by everybody as an intermediary or intermediate product. The plan was that Dow was going to receive the ethylene and then use it in its own plant to make polyethylene pellets that it was going to then sell on for others to turn into plastics. Now, Dow could have built its own ethylene plant, but for the sake of efficiency, it made more sense to it to buy the ethylene, this intermediate product, from Nova. The agreement gets signed, it gets implemented, and then a problem arose. It turns out there was not enough ethylene coming out of the plant for all of Nova's customers. And so Nova provided to Dow, contrary to the agreement, they provided less ethylene than they had promised. And Nova was found to have breached the agreement in not providing the required ethylene, or all of it. So the question then became, well, what could Dow recover as damages? And what it wanted, of course, were the profits it would have made on the sale of polyethylene, not just the lost value of that intermediate product, the ethylene. In other words, the question was, if under the limitation of liability clause, that I'm sure you've seen many of them, under that clause, were the polyethylene profits excluded as indirect and consequential damages. And so only the ethylene loss could be recoverable as damages. So let's take a look at what the clause had to say. And I'll go through it in a minute, but first I'd like to just give you a little bit of background of two of the legal principles that the Court of Appeal relied on because they're important background. The first is that there's nothing inherently unreasonable or sinister about an exclusion clause in a freely negotiated contract. Everybody knows that. The second is something that doesn't get as much attention, which is the Court of Appeal said that parties insert exclusion clauses or limitation clauses in contracts in order to provide certainty. That's fine so far. And in order to order their commercial affairs by allocating risk in a manner different from what would be otherwise provided by law. That is, to make a change from the common law. Now, in that context, let's look at the words here. I'm not going to parse all of it, but you'll see that the clause excluded liability for the defined term damages, but there was an exception for willful conduct. And to skip to the end of the story, the court did find that there was willful conduct here, or misconduct, because Nova had deliberately provided less ethylene than it had contracted for. But in this context, what was excluded on top of this was excluded damages, so they didn't count. So you'll see on your screen are the definitions we need, but it's important as you read through this to remember that the polyethylene lost profits were that was what was at issue. Did they fall within the meaning of excluded damages so they couldn't be collected? And you'll see that the words in red that you see for under excluded damages, they capture loss of profits and damages arising from loss of production. So the question was, well, does that include as excluded damages all forms of lost profits, or only the kind that are direct and consequential, which are the lead-in words to that parenthetical? And if that's the case, what exactly are those indirect or consequential damages that are being excluded? And then if you look at what the profits that Dow expected to get, which of them are direct and which of them are the excluded indirect damages? So it's quite a complicated argument. Now, the Court of Appeal, moving on to the next slide, interpreted the contractual clause as the words that we just saw as compared to the allocation of risk that would have applied at common law. And believe it or not, the Court of Appeal focused on everybody's favorite case from law school, Hadley and Baxendale. And I note, by the way, Hadley and Baxendale doesn't use the words consequential or indirect or direct for that matter. Instead, you'll remember that what's recoverable under Hadley and Baxendale are damages that arise naturally, which the court said were the things that were in the contemplation of the parties at the time, or arose from special circumstances where the circumstances were known to the parties. So those were the branches of the common law test. So going on, the court's analysis was very interesting against this background from Hadley and Baxendale, because polyethylene was not mentioned in the contract at all. So the Court of Appeal found that the agreement as a whole was really about ethylene. So what were direct damages? Well, the value of the ethylene, reading the contract as a whole. And then they turned to the limitation of liability, particularly the excluded damages definition you see on the screen. And the court said, well, this has to mean something. It must be trying to exclude something practical on the ground that would have been recoverable at common law. Well, what was included at common law? Well, the downstream profits, the court said, of the polyethylene pellets were contemplated by the parties at the time they entered into the contract. So that fits within Hadley and Baxendale. But it found that because polyethylene was not the subject of the contract, that those profits were indirect and so were excluded. One other interesting thing that the court took into account is they said, well, Nova Chemical, the company that was making the ethylene, its fee that it was getting to make this product was quite modest. So the parties must have intended in the excluded damages definition to be expansive. That is, that the risks must have been quite modest, risk to Nova, if the fee was quite modest. And I'd also note, really in passing, that unlike some of the cases we've looked at over the years, the court did not really parse the words carefully, what indirect means, what consequential means, look at the dictionary, and so on. It was a much wider analysis of the contract as a whole, that led to the result. So let me ask a question, and we can put up a poll to help you answer. Do you agree with the court's ruling in this particular case? The words indirect and consequential damages appear in many, many agreements. Do you think the court got it right doing this kind of analysis, where it had to really get into the substance of the business between the parties instead of looking just at the words of the clause? So let's give it a few more seconds and then we'll pull up the results. So if we can, let's get those now, please. So here we go. So the vast majority of the folks here, 71%, agree with the court's ruling, but quite a large minority think that the court got it wrong. And one of the downsides, I have to say, of doing this by webinar instead of in person is that I don't get to follow up with some people, as I usually do, and ask, why do you think X? Why do you think Y? So that we can have a bit of a discussion. And just to move away from this for a minute, I'm delighted that so many of you are here and can join us, but boy, am I looking forward to the day when we can do this again in person. And I encourage all of you, once COVID is over and we can do this live, we always offer it partly by webinar, but if you can and you're in Toronto, I encourage you to drop by in person because it's quite a lot of fun to be able to have some back and forth, as well as talking before and after the session. All right, so let's take down that poll. Let's keep going. So what's the lesson here with respect to contracting? The generic phrases, I'd suggest, like indirect and consequential, are usually interpreted in an extremely contextual manner, like we're seeing in this case. So if something's important to you, you can use more words to exclude it or to include something if it's important and it's capable of being made specific. The second thing is you can also, if you decide to use this phrase, recognize the risk associated with the words indirect and consequential, and that leaving those words just as they are without no other guidance does give the court a lot of discretion on what to decide, because the words don't have a standard one-size-fits-all meaning. They really will be interpreted in the context of the court's view of the business transaction and the agreement as a whole. Okay, so let's move on to the next case. If you'll just give me a moment as we do that, I'm just glancing at some of the questions that have come in through the Q&A. So one thing I'd ask, by the way, is because of the way we're doing it, and I have to sort of go back and forth and look at what you're doing, sometimes I get the question after I've moved on to a new case. So when you send the question, if you wouldn't mind just remarking which case it's about, so I have a little bit of context and can help answer it. So I think I'm going to come back to these and try and move to them afterwards and work them in. Okay, so let's keep going. So this case, the Resolute in Ontario case, I'm bringing this up because the last time we were all together, which was in person, we discussed this decision when it had been addressed by the Ontario Court of Appeal. So I'm going to move through it pretty quickly. And the reason I'm doing it is because we learned all about the Court of Appeal decision, but a little while back, that decision was reversed by the Supreme Court of Canada. So we're going to revisit it. This is a case about the forestry companies Resolute and Weyerhaeuser, who were found liable for environmental remedial work related to some land. And to greatly oversimplify the facts, in 1985, Ontario granted the then owner of the land an indemnity for damage caused by pollutants. And I'm going to show you the words in a minute of the indemnity. And that was all in the context of a settlement about mercury poisoning litigation that had been brought by some First Nations. Now, after that indemnity, the plant changed hands several times. And 26 years after Ontario gave the indemnity, the Ontario Ministry of Environment made a remediation order about the mercury that was on the plant site. And of course, there was a huge cost to cleaning it up. And the question was whether the 1985 indemnity applied to the new remediation order. Now, the trial judge said yes, that the indemnity did apply. The Court of Appeal agreed. And as I mentioned before, the Supreme Court of Canada reversed the Court of Appeal in a decision 4-3. And here on the screen, you have the indemnity clause. I'm not going to read it to you, but you'll see that that clause talks about statutory claims or otherwise. That sounds kind of regulatory. Talks about claims by government. Talks about claims that are because of the discharge or escape or presence of a pollutant, including mercury. So the Court of Appeal and the trial judge had said this clause applied to the mercury regulatory issue. But what the Supreme Court found is that the factual matrix had not been given enough weight in the courts below in interpreting the indemnity. And they said this indemnity had to be read not just in the context of the agreement in which it was found, but in the context of all the historical facts and prior agreements. And the Supreme Court also disagreed on one of the key findings of fact, which is a little bit unusual in this kind of case, essentially about whether the site was experiencing ongoing mercury contamination. And the Supreme Court of Canada also said that there was nothing in the indemnity wording itself about it applying to the costs of regulatory compliance, despite it referring to statutory claims made by government. So these words you see on the screen were clear enough for the Court of Appeal and the trial judge to apply them to a regulatory order, but it just didn't hold up when the Supreme Court looked deeper into the facts. And the Supreme Court found that this indemnity did not cover the government's first-party claim. It was only going to cover third-party claims. So here I'd like to ask if you can use the Zoom chat feature as opposed to the Q&A feature. And maybe respond to the whole group and say, what could have been done differently in drafting this 1985 indemnity that you see on the screen to bring more clarity when in 2007 the regulatory issue arose? So you're welcome to put your thoughts right into the chat, even as we go on and continue. Or I suppose the other question really is, or lesson is, should I not talk about a case until we're all dead sure that all the appeal rights have been exhausted so we don't have to revisit the case later if it gets overturned on appeal? So please do put in your comments, and we'll see if we can get a conversation going in the chat about whether there's anything that could have been done about the drafting of this clause to improve its clarity. All right. The next case, let's move on to that, is an insolvency case. Chados and Deloitte. Deloitte is just here because they were the trustee in bankruptcy. So this is a case that the Supreme Court of Canada that originated in Alberta, and it was decided only last month, and it was an 8-1 decision. And what it's about is how to deal with a contract in the context of the bankruptcy of one of the contracting parties, which is unfortunately a very timely subject in light of the many pandemic accelerated insolvencies that we're seeing these days. Now, before going into the facts of this case, I just want to sort of level set a little bit. We all know that there's a risk associated with termination for bankruptcy or insolvency clauses. In contracts where a party has not yet performed all their obligations. It's a contract that says the contract can be terminated when there's a bankruptcy, or insolvency is generally not enforceable when a bankruptcy proposal has been filed or a CCAA proceeding's been started. So generally, I'm overgeneralizing a bit, when you have these executory contracts, a termination for insolvency or bankruptcy provision is just not enforceable. So in this case, that's not what happened. This case is about an attempt to enforce a more nuanced contractual approach to the bankruptcy of a counterparty. So here are the facts. So Chandos made a subcontract with a company called Capital Steel. And they agreed that Capital Steel would pay Chandos 10% of the subcontract price as a fee if Capital Steel became bankrupt. And you can see the words on the screen. And so what happened was, in this case, Capital Steel did file for bankruptcy. A trustee was appointed who said, Chandos, you owe Capital Steel, essentially its creditors, some money. And Chandos said, well, hang on, I want to set off from what I owe this 10% fee contained in the provision that's on the screen. Now, the Supreme Court of Canada found the 10% fee was invalid, but it wasn't invalid because of the reasons that at least the specific reasons why the courts invalidate termination in the event of bankruptcy clauses. The court applied something called the anti-deprivation rule to this more nuanced situation where there was no termination, there was just a fee. And what the anti-deprivation rule says is that it renders void a contractual provision where on insolvency or bankruptcy, value is removed from the creditors and placed in the hands of other parties. Now, that it's a common law rule from before we had bankruptcy legislation in Canada, but it's never been eliminated by Parliament. And what the Supreme Court said in the Chandos case is that it's an effects-based rule. That is, the question is, did the contract, in this case the fee, result in a deprivation to the creditors? Not whether, when the parties entered into the contract, was this particular provision commercially reasonable? And in that regard, I found the dissent of Justice Cote interesting. She said, well, this provision has a real commercial purpose because the bankruptcy of a subcontractor causes the general contractor to have to make more effort to mitigate the fallout of the bankruptcy. That is, she said, the fee is appropriate compensation for the bankruptcy itself, but the other 8 judges of the Supreme Court of Canada didn't agree, and so this provision was found to be invalid. So then the question I've been asked before and I've asked myself is, well, in what circumstances can you do any better? And I'd say the best answer is that in most situations, it's nearly impossible to tie contractual consequences to the bankruptcy or insolvency of a counterparty, whether it's termination or a fee or something else. Now, how do you get around it? Well, in some circumstances, maybe you can tie termination or a fee or something similar, not to the bankruptcy or insolvency, but instead to some kind of operational impact that you'd expect to see from an insolvency. So if there's a performance obligation that happens constantly or quite often, maybe you can tie the provision to a failure to perform. That might be difficult to negotiate. That, for example, if somebody doesn't deliver goods on a certain day, instantly the contract can get terminated. More usually you'd see, provisions related to material breach and cure periods and so on. But the mere act of insolvency or bankruptcy is something it's very difficult to get a consequence is tied right to. And I'd also note that if you try and do it with the anti-deprivation rule, you'd always be at risk of the courts looking at it and saying, this is just a badly disguised attempt to get around the anti-deprivation rule, and it won't work. Just going to take a minute to look at the some of the questions here. So we have one question about whether there was any discussion in the Chandos case about the 10% provision not applying because the agreement terminated for cause on bankruptcy. And the answer is no. Here, there were the normal termination provisions, but really what was at issue is the parties tried something more nuanced, not termination, but instead tried to recover a fee. So, and we also have a question that asks, why do so many contracts have termination provisions that provide for termination upon bankruptcy insolvency? And I think the answer is, to some extent, history. They're in precedence, and they've just been rolled forward in all situations. I think the other answer is the rule that I talked about before, about you can't get termination merely as the result of a bankruptcy. It's called an ipso facto clause. That legal principle applies under the Bankruptcy and Insolvency Act to only executory contracts, that is, contracts where there's still an obligation to perform. Obviously, there are lots of contracts where the performance has happened, but it's important to still have the contract in effect for lots of other reasons. So it could be completely appropriate in those kinds of contracts. Let me just take a minute and see if there's anything else. I'm not going to repeat them all, but if you look at the chat feature, people have come up with some great suggestions about a lot of these things about to handle these provisions. And I do encourage you to keep adding to the conversation and read it as we go along. This is just terrific. Okay. So, and let me just look over. Unfortunately, I've got multiple screens here from chat and Q&A. All right. So there's a question that comes out about, well, maybe not just a fee, maybe in a shareholders agreement, what happens if somebody comes bankrupt and there's a forced share sale or some other consequence. So this is the guidance I can give you, is that, and I'll repeat, what the anti-deprivation rule does is it says that a contractual provision where an insolvency or bankruptcy has the effect of removing value and placing it in the hands, has the result of moving value from a creditor to the hands of somebody else, that's what triggers the rule. There are probably situations where there's no deprivation of the creditors, where there's something else going on, something transfers that has no value to the creditors, and that could be fine in the circumstances. So again, all these situations have to be quite finely parsed. All right, let's move on. And before we talk about the depths of contract negotiation, let's put up the final poll, if we can. If a party mistakenly says something that is material and incorrect during a negotiation, can the signed contract later be undone? I am sure that every one of the hundreds of people, and I can see from the count that it's hundreds of people participating today, that everyone engages in negotiations of contract. That's a standard part of all of our jobs. Maybe a little less mine, since I spend nearly all my time litigating or arbitrating cases. But certainly the other folks on the line would know the effect of, if they say something incorrect but material, what happens to the contract. Let's just give it a few more seconds. Please click away and participate. And I'm very glad to see, by the way, the large numbers of people who are participating in these polls. I can promise you that this one will be the last one today. All right, so let's close the poll and bring this up. So we'll see that about half the people said that the contract can only be undone if a party was negligent or fraudulent. 29% said it couldn't be undone at all. And 22% said, yes, the contract can be undone where somebody says something during the negotiation or in the lead up to the negotiation that's material and incorrect. So let's bring that down and take a look at a case about this issue. And I apologize, my notes just closed, so I'm going to open them right back up if you'll give me a second. This is one of the dangers of doing this entirely electronically instead of with paper notes. You know, like everything else during COVID, it's at its upsides and downsides. Okay, so let's deal with the Deschênes and Lalonde case. It's a decision of the Court of Appeal that came out last May. Some people may be surprised by the result here, but I'll remind you it is a very recent decision of the highest appellate court in Ontario. And I will tell you up front that it is going to go way outside our technology law comfort zone, because we're going to talk about this case, which involved a contract dispute between a person sexually assaulted as a child by a Catholic priest. Now, Ms. Deschênes sued not just the priest, but also the church. And the church asserted that it had no knowledge of the priest's prior abuse of other people. Now, that was an important fact because it could have an influence on whether the church was liable for the conduct of the priest. And since the church's liability for the priest's acts were uncertain, Ms. Deschênes settled her lawsuit in 2000 by entering into an agreement with the church to pay her some money. Now, 6 years later, in 2006, it came to light that back in the 1960s, 3 girls had complained to the police that they had been sexually assaulted by the same priest. And the police had forwarded the girls' statements to a bishop of the church. In other words, the church made a misrepresentation leading up to the negotiations of the contract with Ms. Deschênes, but the court found that it was what it called an innocent misrepresentation, in the sense that the court believed what it said when it said it, after having done reasonable diligence. That is, the court had gone and done some looking into the allegations against the priest and whether there were previous allegations, but it just had not found at the time, by the time the settlement was made, these old police records that had been sent to the bishop. Now, based on this innocent misrepresentation, the Court of Appeal found that the contract was invalid because there was and I'm going to go through the 5 factors. There was a positive misrepresentation of current fact that induced Ms. Deschênes to make the contract. She acted promptly on discovering the misrepresentation. No third party had acquired rights for value, and the parties, the church and Ms. Deschênes, could be restored to their pre-contract positions because this just concerned money. So as a result of all those factors, the Court of Appeal found that the contract was rescinded, which gave Ms. Deschênes the opportunity, both if she wanted to pursue her lawsuit or reach a new agreement with the church based on the new information that was available. Now, this is a tough one. What are the lessons here where an innocent misrepresentation can lead to the rescission of a contract? Now, many of you work with or within large organizations, and I'm sure you ask around before making a definitive statement in the lead up to or during contract negotiation. I have no doubt that you do some reasonable diligence, but sometimes innocent mistakes get made. Now, it's worth noting, I'd say, that most of the time, those kinds of innocent mistakes have no consequences because they're sometimes not relied on by the other side, or the mistake never comes to light as a practical matter. And lawyers very often use words to avoid definitive statements in the first place, like maybe, likely, in my opinion, and so on. But I'd suggest that where a key statement is going to be made that will drive a negotiated result in the context of an important contract, where it's crucial that the contract not be unwound later, then in those circumstances, maybe it's a good idea to do more than reasonable diligence and instead sweep all the corners, or at least advise the client of the risk of not doing so. So I don't know if we did the poll again, which we're not, if we'd arrive at a different set of numbers about what you think the result may be. Obviously, this case comes out in a completely different context, but we can see that this is the law from the highest court in Ontario. Now, just looking at some of these comments. So one of the questions that's come in is, how would you know exactly what is material for the other side? So I think a lot of the time you don't know, but a fair bit of the time you do. Through negotiations, people do try and get to what each other's interests are and may have an understanding of what was material to them. That isn't always the case. But one way in certain kinds of contracts, for example, in RFP situations, the parties can actually lay out what's important to them and put it in the request for proposal type documents, or more informally. Interestingly enough, another question has come in about the, a variety of questions about the integration clause or entire agreement clause. The court did not analyze it from this perspective. And I think it's fair to say it may be a subject for another day to talk about what the effect is of integration clauses and when they are effective and when they are not. But I think there may be some surprise about how effective they can be and when they can't be, and what evidence does get looked at in that context. What's important to note here is that innocent misrepresentation is actually a tort, where the relief that was granted is a contractual remedy, that is rescission, but it's done under tort, not contract law. Okay, so let's, looking at the time, let's keep going a little bit. All right, so here, if we pull up the next case, this is another case I think we can cover quite quickly. I'm dealing with this case in part in memory of my late father. As a kid, when I told my father something cost X dollars, he immediately barked back at me to say, plus tax. This is a case about some folks who apparently didn't have parents who taught them that lesson. So Auto Modular made parts, as you might expect, to be installed in cars manufactured by General Motors. And there was sales tax on the supply of those parts. General Motors eventually terminated its relationship with Auto Modular, and Auto Modular sued GM for $25 million. After some litigation, GM and Auto Modular made a settlement contract. Might be interesting to note they did it working through the family day long weekend, which may explain what I'm about to tell you. So the settlement contract required GM to pay $7 million to Auto Modular, and there was no mention of in the contract of sales tax. Afterward, Auto Modular correctly said $7 million is owing, sales tax is owing on the $7 million payment, and said, GM, you have to pay me the amount of the tax, which was $910,000. Auto Modular effectively said that the contract required a sales tax gross up. It had to be implied into the contract. General Motors said no, the contract doesn't mention tax, and that should be the end of the matter. Well, the judge in this case ruled that GM did not have to pay Auto Modular the $910,000. And the nice turn of phrase was that an all-in number, that is the settlement number, an all-in number is just that. And that the court was not prepared to imply into it an obligation to pay the tax on top of the amount. Now, the lesson here, I think, is fast, quick, and obvious. Always deal with taxes in a contract, every kind of possible tax. I can't tell you how many disputes land on my desk where one of the issues is, not usually the only issue, but one of the issues is, well, what happens to the tax? Who pays the tax? And sometimes it's much more complicated. For example, in M&A situations than just sales tax. Okay. Before we go on to talk about good faith, let me just quickly check the screens again. There are a lot of comments here, so I apologize in advance. I'm not going to be able to get to all of these. Okay, but I have been trying to sort of work them in as I go. One thing I will say is there are some of you, when you're using the chat function, are directing your questions just to the option called panelists, some to everybody. My suggestion is you click all panelists and attendees so everybody can see what you're saying in the chat and have the benefit of what you've written down here, because some of it is really interesting. Okay, so good faith returns to the Supreme Court of Canada. So in 2014, you'll remember that the Supreme Court made a major decision about good faith contractual performance. It was the Bassett and Renew case. We covered it in one of these events, God, I don't know, 5 or 6 years ago. And there have been many court cases since then trying to figure out how to apply that good faith ruling, including one I argued actually for Oracle in the early days of trying how to decipher the Supreme Court's decision. But we now have 2 contractual good faith cases that are at the Supreme Court of Canada awaiting decision. They were both argued last December. And so the decisions in those cases could come anytime now. Now, most of you know that we were going to do this session March 25th earlier this year, which we obviously had to postpone because of COVID and because I maybe, well, for sure, overly optimistically thought by the spring, it would all be over, which unfortunately I was completely wrong. But back in March, these cases had just been argued. It's now been almost a year. So really, we could get a decision any time now. And late yesterday, I went to look to see if, to double check really that the decisions had not come down, but could be any time. So I'm going to very briefly tell you what they're about so you have some context when they are released. So the first of the 2 cases arose in Ontario, and it's the CM Callow and Zollinger case. So in this case, and some of you will wonder, I'm sure, like how this is the case that got to the Supreme Court of Canada. But this is a case about the Callow Company, which is really about a guy named Mr. Callow, who provided landscaping maintenance services to a group of condominiums. And the contract he had with the condominiums provided that they had to give him 10 days notice of termination of the contract. Now, what happened is the condos decided months before the end of the term of the contract that they were not going to renew it. And in fact, were going to give notice of termination all that time later. But what they decided to do is that they made the decision not to terminate, but they did not give the 10 days notice until much, much later in the process. And in between deciding to terminate and giving formal notice of termination, Callow gave the condos all kinds of freebie work, and freebie actually is the word used in the decision. And he was hoping to persuade the condos to renew the contract. The condos accepted the freebie work, even though they knew that they would be terminating Mr. Callow. So the question for the Supreme Court of Canada really is, did the condos act dishonorably enough to breach the legal requirement of honest performance that was created by the Supreme Court of Canada in 2014. And interestingly, in oral argument in December, there was this discussion about, is there a distinction between knowingly misleading someone and failing to disclose? So stay tuned. Like I said, could come anytime now for us to get the answer. Let's deal with the other case that was argued in December about good faith. It involved WASTEC Services and the Greater Vancouver Sewerage and Drainage District. And this case actually arose out of an arbitration. It might be a good time to pause for a second and just introduce you to the Silicon Valley Arbitration and Mediation Center, which is our newest sponsor for this series. Silicon Valley promotes the use of arbitration and mediation in technology-related business disputes, both in Silicon Valley and around the world. It's got members all over the place. And it puts on CLE events and engages in thought leadership and lots of other things. It's a great organization. So if you don't mind, let's return from that commercial break and go back to WASTEC. So WASTEC had a complex 20-year agreement to dispose of Vancouver's waste. And the waste could go to 3 facilities. If the waste went to 2 of the facilities, it attracted a lower rate. And if it went to the 3rd facility, it attracted a higher rate. And the economics of the deal were driven in large part by what the allocation was between the waste that went to the high cost or high price site and the low cost sites. And all of this, the economics, the profit margins that were expected to be made, it was all known to both sides. But the target, like the target economics, was not written into the contract itself. It was just a common expectation. Now, under the contract, it was up to Vancouver to decide how much waste went to each of the 3 facilities. And in 2010, Vancouver changed the allocation between the facilities in a way that made it impossible for WASTEC to reach the target economics. The arbitrator in the case ruled in favor of WASTEC, but the courts have overturned that arbitral decision on appeal. And the Supreme Court now has been asked to examine if the Basson decision prohibits a contractual discretion, that is in this case, the allocation of waste by Vancouver, whether you cannot exercise an contractual discretion that nullifies non-contractual expectations. And in December, in the oral hearing, the court looked at the almost philosophical question of what exactly is dishonesty and how to penalize dishonesty while maintaining commercial certainty. So again, that's another decision to watch for. We're just about, unfortunately, out of time. There are really a lot of materials here. I'm going to go through them. It may be that this will be the material we'll have to cover the next time. But I do want to take our last few moments together to thank iTech Law, Cantech, TCLG, and Silicon Valley for helping us put on this event. I'm honored that you're here. And I also want to thank on your behalfs, Sandra Montanino and Charlene Wagner from Goodmans. Every time we put on these events, everything goes smoothly. Sandra and Charlene, it's because of you, and we really appreciate all your efforts. So as we hit 2 o'clock, let me just thank you very much again for joining us. And hopefully we can all do this again live and in person sometime soon. So at the very least, we can chat before and afterward, nibble on one of my mother's cookies. And really, I wish you all to stay healthy, and I look forward to seeing you the next time. Take care.